The criminal justice system sometimes works and sometimes it doesn't work. Today, you're going to hear about a case that didn't work at first, but it worked later. And it worked later because of exceptional lawyering by someone who was willing to do the work, willing to take chances to investigate the claim and investigate the scene. Every trial lawyer has that one case, the one that pushed them to the edge, changed how they practice, or kept them up at night. This is Trial War Stories, and I'm your host, Andy Goldwasser. I sit down with great trial lawyers to unpack unforgettable cases, the strategy, the chaos, the pressure, and the moments that turn the tide beyond the transcripts and verdicts. And now, to the show. My guest today is the one and only Ian Friedman, a dear friend, actually all the way back to law school.
Since law school.
When I started this podcast, Ian, you were the first person that I thought of that I wanted on. So now we're in season 2. It's been way too long to get you here. I know how busy you are, but I'm so appreciative of you coming on the show today. Thank you.
Well, thanks for having me. I appreciate it. And I'm honored to be here.
Yeah, thanks. Ian is the go-to guy when it comes to criminal defense in Cleveland. And truthfully, I don't even know how many cases you have in Cleveland anymore. It seems like your practice now is all over the world. In fact, I think when I called you to beg you to come onto the show, you were in either Israel or Abu Dhabi or somewhere. What are you doing with your practice now?
Yeah, so we're based in Cleveland, and I would say half the practice is here, half elsewhere, and that could be across the U.S. or internationally. And yes, I was in Italy when you called me, and on my way to Israel for a international cybercrime case that we were handling. So
it's so amazing to me because I remember our law school days, and who would have thought? I mean, the two of us were sitting in the back of the class, right? It's just crazy. So you know that this podcast is about trial war stories, and gosh knows you've had plenty of trial war stories. And so maybe the hardest thing about this particular episode was deciding which one to pick because there's so many fascinating cases. Tell us about the case you chose and why you chose it, and then tell us a little bit about the case itself.
Yeah, so it was kind of difficult to figure out which case to talk about because there have been so many that have been meaningful for various reasons. But I chose this case because it really gives a picture from start to finish. It talks about minute one all the way to, even though the case was more than a decade ago, it still goes on, and you'll understand why that is as we talk about it more. But it still is going all these years later. And to me, it kind of shows the part of criminal defense that I love the most, which is the people and the relationships. And this trial, as difficult as it was, is now about relationships. And so for me, it's very meaningful. It's very personal for me.
And we're going to get into the case for a moment. It's also about the criminal justice system working, and it doesn't always work. Well, at least it worked in part, and you could maybe talk about that.
In the end.
In the end, it did. And when you told me about the case that you selected, it was a difficult case for me personally because so much of my work is representing victims, and I'm a board member of the Cleveland Rape Crisis Center. So this one was a tough one to talk about, but I think it's an important case. And it's an important case because of it really does show the importance of not only great representation, but the criminal justice system, how it's supposed to work, at least in the end. Tell us about the case.
Yeah, so this is a case when you and I were talking and you said pick a case, I was hesitant on this case because of the type of case that it was. It was a sexual assault, rape case involving a minor. The alleged victim in the case was, I think, 6 years old at the time. that's as difficult a case to handle as it is to talk about. The most commonly asked question of any criminal defense lawyer is, how can you represent those people you know are guilty? And I know they're thinking of murder cases and these cases. And even though people have their rights and everyone acknowledges that, when you get into a case where there's a sexual assault and a minor, there's the cringe factor, and people rush to judgment a lot more quickly in those cases. And even though there's no, there's the presumption of innocence in all cases, in this type of case, it's very different just because the child involved and the nature of the claim itself. It was important, though, to talk about because, I'll tell you what this case taught me. Let me just start maybe this way, and it'll help. So when you heard what kind of case it was, and as you're starting it off by saying you're part of the Rape Crisis Center and so forth, we have to think about this from minute one. How's this going to resonate with the judge? How's a jury going to be impacted by this? And this was the case that started me with a question that I use in all of my voir dire, my jury selection. And it begins like this, because your listeners have to understand that when the jurors come out, the judge tells them what kind of case it is. And inevitably, I stare at the jury when they're hearing what it is. And many of them, all of a sudden you kind of see them reel back, or they look over very quickly to the defendant because they're shocked by that.
Right.
So the first question I always ask of them is, can you think of anything worse than being accused of child rape? First question I ask them right out of the gate. And some of them may say murder, but they're hesitant to even do that because many of them would rather be charged with murder. Most of them can't think of anything. And so then my response after we've gone through all of the potential jurors is, well, could you imagine being wrongfully accused of child rape? And now all of a sudden they're kind of like, oh, wait a second. And it puts them where they need to be, which is not just are we here to prosecute, but we're also here to defend the innocent.
You are, and it's almost reframing the victim.
It's reframing. Correct.
And that's a hard thing to do, because when you ask that question of the jury, my response, if I was a potential juror, well, I could think of something that's worse, being raped, right? That's worse than being accused of rape.
That's right.
But I really like the way you frame it, and that's one of the things that makes you such a great criminal defense lawyer is you spend so much time thinking about your case. Tell us, though, about this really interesting set of facts that led to your involvement and then the case itself.
Yeah. So I'm not obviously going to name the person. We'll just say the defendant in this case. We got a visit from his parents in our office, and they had said that their son had been convicted of child rape. So he was actually convicted in the Cuyahoga County Court of Common Pleas. They wanted us to handle the appeal in the case, myself and my partner, Eric Nemechek. We went over all the case facts with them. The lawyer that they had tried the case to the bench, so meaning just to the judge, not to a jury. And the conviction was there. So we were talking about it. What does an appeal look like? How's it different from a trial? And there came a point in the conversation an hour or two later into it where his mother asked, well, if the appeal is not successful, when will he get out, after he does like early time and gets, paroled and all of that? And I was actually really surprised that that was her question, because the answer is, if you're convicted of that charge, you don't get out. Life means life. And so I had to tell her that. And I'll never forget, the mom went right off the chair and virtually passed out.
That has got to be so hard for a parent.
Yeah, well, I was shocked she didn't know that. The case had been going on, for a year. The conviction was there, and she had no idea. She really thought that at some point he'd be able to get out. And so we were looking at someone who was in for the rest of their life. So we were starting this case from really 6 feet under is where it was. So what he was accused of and at that point convicted of was he and a friend went to a woman's house. She and one of her friends were there. It was late at night on a Saturday night. They were, having some drinks together, just socializing and so forth. in the kitchen. This was a home in Shaker Heights, which becomes important actually at some point. And somewhere late in the night, well after midnight, the woman's daughter came walking into the kitchen. And as I recall, she was 6 years old. The child stayed in the kitchen for a while in the middle of the night. And at some point, mom said, look, you've got to go to sleep. Can you help put her in the back into her room? So the defendant, the client, in this case, now he'd become our client. The client in this case helped kind of bring the girl back into the room and kind of helped pick her up to put her into the bed. Shortly thereafter, he returned back into the kitchen right away. But shortly thereafter, the girl called out to her mom. Mom came and went into the bedroom, and the girl said, that man touched me. And if you can think about a snowflake turning into an avalanche, that's exactly what happened here. The woman called her friend in, told her what happened, and
did the daughter accuse your client that same night, or was
same
it the
night? Same night, but it was he touched me, and then mom and friend took her into the bathroom, and the questions were very leading questions, and understandably, a mom being very concerned. Where did he touch you? How did he touch you? Are you scared? Did he touch you here? And the girl in the middle of the night's like, yes, mommy, yes, mommy, yes, mommy. And so the conduct was escalated in an instant to the point where, did he touch you here? Where did his fingers go? What did his fingers do? All of this. And it became conduct that constituted rape by way of charge.
Okay.
So mom came out, said, you have to go. He didn't know what was going on at that point, but okay. So he and the friend left, only to be contacted some days later by a detective in the Shaker Heights Police Department. There was questioning as to what occurred. He said, I didn't do anything. Yeah, I walked her back to the bedroom. Yeah, I helped her get into the bed, but I don't know what you're talking about. And he eventually was charged with rape. And as I said, it then proceeded to a trial to the judge.
Okay. And you did not handle the first trial to the judge, is that right?
I did not.
Ian, is it sort of common practice when you're dealing with childhood sexual rape cases to want to try them to a judge as opposed to a jury, with the thought process that the jury is just going to be too emotional in a case like this and maybe a judge will give us a better shake? Or is it really judge dependent, facts dependent?
Yeah. I think it's judge dependent. I will tell you that, yes, I've tried a lot of these cases, a lot of cases in general, but a lot of cases of this nature. And I can count on one hand the amount of times that I've tried a case to a judge. Most of the time it is to a jury. And I think that effective jury selection kind of helps to seat that jury in a place that you need them with an open mind as to what's going on.
And I have to imagine it's the same. I do civil work, and I have to imagine it's the same in the criminal field. When you try a case to a judge as opposed to a jury, it's more difficult to get that case reversed.
1,000%.
And here
you're
you
giving
are,
up a lot. Yeah.
Here you are brought into a case after the trial, after all the evidence, and I know how important you getting involved early in a case, how important that is to you as part of your practice. But here you are getting involved late, after trial, after a conviction, and with a judge rendering the decision, which makes the case really difficult to reverse.
That's right. You're giving up a lot. There's a lot of potential error that's gone that it's not even to be considered or that you've waived. So it's really difficult. And that's oftentimes one of the reasons why you would bring a jury in so that you can have the evidence and the decision-making process and so forth evaluated by a higher court, should the need arise.
Are you able to talk about how you were able to get that case actually reversed?
Yeah, of course. So my partner, Eric Nemechek, was handling the appeal. And the other thing that we didn't just get the transcript of the trial to automatically take to the Court of Appeals and say this error existed, this error didn't. Because like you said, Andy, it's to the judge. So there's not a lot there oftentimes. What we also did was we had our private investigator, Keith King, join us as part of the team, and we really confronted it two ways. We confronted it on the appeal itself, and we also confronted it looking for a motion for new trial. Was there something about this case that was inherently so unfair that the trial shouldn't stand on its own and we should get a new trial? And luckily, that's where it went in this case. We were able, in the process of getting all the information, we were able to find that after the girl made her claim, she went and spoke to a psychologist. And what we found out after we had subpoenaed all of those records from the psychologist was that she had told that psychologist, she had kind of recanted, and she said, well, I don't remember it happening. And that bit of information, as critical as that is, can you imagine? I don't remember it happening. It didn't, the police officer, the detective from Shaker Heights who was tasked with handling this case, the lead investigator, he never went and looked at those records. He never spoke to the psychologist.
So those records weren't even introduced.
They were not introduced. So we had newly discovered evidence.
Okay.
And that's how this went. So we didn't even have to take the appeal over across the street to the Court of Appeals. We filed a motion for a new trial with the trial court saying, based upon this newly discovered evidence, we should be entitled to a new trial.
Amazing. And you were able to get that new trial. Meanwhile, your client, who's a young man, it's my understanding.
He was.
Comes from a good family, right. Lives in the suburbs of Cleveland, went to a good high school, went to a good college, has been in jail for the last year. That's right. That's right. Wow.
He had never been in trouble before. Like you said, by all accounts, great guy, and just found himself in a nightmare.
So now you're involved and you try the case again, but this time do you try it to the same judge? Do you try it to a jury? What do you do?
Yeah. So actually in this case, we decided not to try it to the judge. We wanted a jury. And we also felt that it had to go to a different judge. So we spoke to the judge in the case. He got off the case and it was randomly assigned to another judge.
All right.
And we proceeded to jury.
Tell us about the trial.
Well, I have to tell you, I have to back up and tell you about the investigation because that's what really helped at trial in this case. So I believe that in any criminal case, you have to go to the scene. Doesn't matter what sort of case it is. You have to go to the scene. You have to smell it. You have to hear it. You got to see it to understand it. And so oftentimes we'll go to a scene and just kind of do a 360 and look around and just kind of get senses for it. And so we went to the house that this occurred at in Shaker Heights. We filed a motion to allow us to inspect the house. So there we were in this house. The accuser's mom no longer lived there. Someone else did. And so the defense team went in and...
Do you have experts with you?
So no, at that time we had the lawyers with us and we had our investigator with us.
All right.
And there we were. So you walk in the front door and there's the living room and you walk straight through to the kitchen. It's one of those old Shaker Heights homes. Remember I told you this is going to be important.
Right.
So they were all socializing in the kitchen. And when mom said, take my daughter back to the room, which still to this day, I don't know why she had him do this, complete stranger to the girl, but that was one of the oddities of the case. He took her back and the room was only about 10 feet away from the kitchen.
Okay.
All right. So that becomes important because we spent a good deal of time in the house walking back and forth. And there was something about the case that bothered me. There was just something, and I couldn't put my finger on it at that moment until toward the end we were sitting in the living room. And then it dawned on me. And it was the floors. It was the floors of this old Shaker Heights house, the creaking of the floors. You couldn't walk anywhere in the house without hearing creaking. And it was loud, like it was clear as day. And so I remember saying to our investigator, I said, do me a favor. I said, Keith, go into the bedroom and just walk around in there. And he did. And you could hear creaking from that room. And so then that really became the theme of the case, which was this couldn't have happened because had it happened, the people in the kitchen would have heard something going on into the bedroom. It was more consistent with what he was saying, which was he walked in, he walked out. There's no way that he could have spent any time or moved around in there without the people in the kitchen having heard something.
Makes perfect sense.
Yeah. So
I don't know how you present that
to
the trial, and I guess you'll tell us about that in a minute.
Yeah, and so that was the big question, right? Like, how do you get everybody to understand that? And we have a mechanism in criminal defense where you can do a jury view, and you could do it in civil law also. And so we said, okay, do we bring the jury out here? And the problem with that was the jury coming in is only going to be a couple of minutes, and they're not going to be walking around the house like crazy. They're just going to stand there, they're going to look around, and they're going to leave.
And the other problem with jury views is that you can't use them with witnesses.
Right.
I mean, it's not like you could bring a witness and the jury to a jury view and then put a witness on the stand and at the scene, although maybe I guess you can do that with the right judge, but it's very rare.
That's right. That's right. So in this case, we kind of did some thinking. We left, and I started thinking about it. And Keith's the investigator. His brother's a builder. And so I was thinking about that, and I called his brother, and I said, do you think it's possible to rebuild that house? And he said, well, you can rebuild anything. And he said, where? And I said, in the courtroom.
Oh, my gosh.
And he thought I was joking at first. I wasn't. And so he went to the house, and in the end, what we ended up doing was rebuilding the entire interior of the house, first floor of the Shaker Heights home. The floor, same type of wood, same everything, same amount of, I should say, lack of cushioning underneath it. The heat returns, the leaded windows, where the kitchen was, to the hallway, to the bedroom. And we had filled up the hallway at the courthouse prior to trial with all the wood. It was a lot. People who saw it have to still remember it to this day.
This is incredible. So in this replica, when it was set up, when you would walk on it, would it creak like the original house?
Yeah. So the idea of it was to actually build the house and show the jury that, I wanted them to see the space, the distance of everything. And so it was ready to set up. But what we ended up doing in the case, we actually didn't need to ever set up the full house. What we did do, though, is we put down the flooring of the house, which was the flooring of the kitchen to the bedroom in the hallway.
Incredible. And now you can actually use it with witnesses.
That's right. So we actually stood once the witness, who was the owner of the home, the mom at the time, came in and gave the foundation, authenticated, said, yeah, that's how the floor would have looked. And once she said that, we were able to keep the floor there. And the great part of it was we tried the case on the floor of the house all week long.
Oh, my gosh.
Yeah.
That's incredible.
Yeah,
Can I back up for a second? Because I'm just so interested from a lawyer's perspective. This may not be interesting to non-lawyers, but from a lawyer's perspective, it's always difficult, as you mentioned, to make sure that the proper foundation is laid so that you can actually use that as evidence at trial. Here, unlike a civil case, you don't have the benefit of depositions. Was there any concern that you weren't going to be able to get this into evidence?
Yeah, so of course there was concern, but we had it kind of two ways. Mom said, yeah, that's the floor. So we were good there. But if she said, I don't remember, or that's not it, our investigator was ready to say, here were the measurements I took at the house. These are the same measurements here. So we felt we had it both ways, but we were able to get it in earlier through the mom, which worked to our benefit, because trying the case for the week on the floor really made its point. As we walked back and forth questioning witnesses, the jurors, they heard all week long.
Amazing. And what a way to keep the jurors' attention too, right? I mean, they could see it, they could feel it. That's incredible, Ian. Was mom, I assume she was called pretty early by the prosecution.
She was.
And so you cross-examined her in order to lay the foundation to get the floor in.
Correct.
And once that was done, you could use it throughout.
Correct.
Did you actually so you just kept the floor down the entire time?
The floor was in the courtroom all week long, yeah.
That is amazing. Yeah. I mean, you talk about demonstrative. That's demonstrative.
It was definitely demonstrative. And there were a couple things about that case that really I still remember today. One, cross-examination of the young girl and just how suggestive questioning could be to a child. Because when questioning her about what was going on in the middle of the night, there was testimony about mom and her friend doing a seance with our client and his friend. and trying to recall spirits and so forth in the kitchen. And of course, we said to Mom, nobody appeared as a result of the seance, right? And she said, no, but we were playing around with it. But when her daughter got up there, we're able to say, and it was pretty neat when your grandma came back into the room, right, as a result of the seance. And she said, yes.
Wow. So she was like 8 or 9 at the time of trial, I assume?
Yeah, by that time she was. That's right. And she recalled things and testified honestly. She truly believed that these things happened that could not have happened and that the parents, her mom said, didn't happen. So that was number one, just how easy it is for a child to believe something.
That's why child rape cases are so difficult, because the child doesn't lie.
Correct.
So the jury actually believes the child.
Right.
And I don't know if I've ever had a case where I've had to cross-examine someone that young. Was that a difficult thing for you?
It's terrible. There's nothing harder in criminal defense than cross-examining a child in a sex case. The emotions are running so high. The way that you have to do it has to be done so delicately. It's extraordinarily difficult to do. The jury wants to believe the child, right? And you just said it. You said a child doesn't lie.
A child doesn't lie, and you can go after experts all you want. Right. I mean, the jury almost expects you to go after these paid experts, but man, you better not go after a child. And to your point, you better not go after a child in a sexual assault case.
It's extremely difficult. So that's why the way that it was approached in this case was, I really leaned into the fact that she believed that these spirits came back and spoke to her. And so the jury got to see that maybe she doesn't believe she's lying, but she's just not accurate in her recollection as to what's going on. So it was kind of mission accomplished without attacking her.
That's a fantastic way to cross. So did the government call her the child in its case?
Yeah, so the government did.
Okay.
That's right. So we had cross-examination.
Okay. Wow. Yeah. That's amazing. So what else happened?
So that was one. And then two, well, there were actually a few parts, but let me back up to number two. I said there were two. There's actually three. Two was the detective in the case. We really spent a lot of time with the detective on the importance of investigation and how if an officer does not do a thorough investigation, wrongful convictions can happen. And I'll never forget when the detective left the stand. He walked down the stand. He kind of walked through the courtroom past the podium. I was sitting in the chair at the table, and he just looked down at me, and he had tears in his eyes. Literally had tears in his eyes. And he just kind of stared up. I remember looking at him like this, and then he left the courtroom and never spoke to him again.
Almost as if he wasn't even sure of his own case at that point.
You couldn't be sure of the case at that point because he literally had to get up there and say, I did a great job. Okay, yeah, but I acknowledge I didn't get these records that showed that she recanted. And I do remember him trying to defend that, but how do you defend that?
You can't.
You can't.
And the other thing that's interesting about that case, I mean, it really is reliant on two people, the child who was 6 at the time and the mom.
Right.
And the mom was drinking that night, wasn't she?
Mom was drinking that night. Correct.
Well, this is incredible.
And a parent wants to believe their child. So this was really like you had all the bad ingredients in one blender. Like you just had it all. This really had everything going against you in this case. But the third and final point was the power of the demonstrative, like we were just talking about. At the end of the trial, the jury had heard us walking up and down and throughout that house on the floor, I don't know, 400 times, 500 times every time we walked, the creaking of it. So that when I said to them at the end, ladies and gentlemen, you know it couldn't have happened because you've heard it here. Had it happened, they would have heard it, and they didn't. And I didn't have to sell it. It was sold. And so that was a case that really stands for the proposition that you got to put out something that they can see and feel and hear. And that really makes the impact upon them. So they don't have to sit there and listen to me say, well, you should believe this. And I look at this and they got it. All I have to do is say, you saw it too.
Yeah. You know, Ian, there are so many lessons that I've taken away from our conversation right now. And I know you actually teach a boot camp to young lawyers. So I'm hoping that they take some things away from this podcast. The first thing is, you have to, as a lawyer, you have to not only do the preparation, but you have to be present in the case. And the fact that you actually go to the scene to be present, it's such an important part of what we do. We just don't get paper, look at that paper that we receive maybe from the government in your case or from the other side in my type of cases and just rely on it. You have to do your own investigation. So you have to go there. You have to be prepared. You can't be afraid to take risks, which is what you did. And you have to do something that's going to capture the jury. And man, you sure did it in this case.
Yeah.
Incredible.
Yeah, thanks.
What incredible lawyering. And so what happened? What was the verdict? Tell us about it.
Yeah, so I'll tell you something that's scary. So on the way, midway through the trial, the prosecutor said, at the start, there was a better offer. You know, if your client accepts a felony conviction, we'll lower the penalty. And it kept getting more and more enticing, let's say. You would think it would be. It got to an offer of a low-grade criminal offense and credit for time served. He had already been sitting in the county jail for a year. So had he literally just said, fine, I'll take this, he was going to go home that day.
That's incredible.
It was really incredible. Now,
I mean, what a hard, that he turned it down.
Turned it down. So now the pressure was incredible because he could have gotten out that day. But instead, I will never forget what he said. He said, if they convict me, then that's what God wanted to happen. And that's what's supposed to have happened. And I'm sitting there and I'm like, I can't believe he's saying this. So the pressure on our shoulders, now it's just us, right? What's standing between a conviction and an acquittal? It's what we do. And the pressure was just absolutely immense, but I knew he was innocent at that point. So when people say, how can you represent someone who you know is guilty? I say it's far easier than representing someone who I know is innocent.
Yeah.
And so there we were representing him. We went through the closing arguments and we felt pretty good about it because we tried to, did the close from the floor. And I kept walking back and forth. The jury did acquit him, thankfully. It was a full acquittal. He was released that day.
What was that like? What was it?
Right.
What's the feeling when you have a case that you're so emotionally involved in? Yeah. There's so much pressure. You really believe your client is innocent.
Right.
And then in a case where he's already spent a year in jail and now he's vindicated. What does that feel like?
It's a shoulder-dropping relief. You don't realize how tense you are. You don't realize how a case has overtaken you until you're released of it. And it's almost like putting a pin to a balloon. And that's really what it felt like. It's just this deflation. And it's a great feeling. I just got chills thinking about it because I was trying to remember what it felt like sitting at the table with them. And I got chills all these years later thinking about it because it is something, there's really no words for it. I've done the best I can giving you the description until you're there and you walk out and I'll tell you what it is. The air is lighter.
Oh, that's such a great description. I mean, in the civil cases, it's different, right? I mean, here you're dealing with someone's liberty who, if the jury comes back with a guilty, that person is going to be either handcuffed or re-handcuffed and taken away, and that's it. So are you like hold your client's arm? Like, how do you take a verdict like that in a case like this? You remember?
I don't remember in this case. I know that I was shoulder to shoulder with him. Knowing myself, I'm sure I probably did have my arm around his back, just knowing how I am.
Right.
And then I remember the hugs that went around, the hugs between him and the investigator, and then the family and friends who were behind us. There were a lot of hugs.
Is it hard when you have the accuser and the accuser's family in the courtroom who, notwithstanding the jury's verdict, they probably believe that this individual was guilty?
Yeah.
And you feel bad for them, right? I don't know what their motivation here was, but do you get like a sick feeling with the other side just being there, or are you so focused on your team and your client that that's really what matters at that point in time?
Yeah, that's a good question. So I think it differs, right? I mean, we have some of those cases where I believe an accuser is just outright lying. And the answer is I don't feel bad at all when that comes back. And in fact, sometimes I believe it's deserved if someone's crafted an accusation with some ulterior motive that we've been able to show. But there are those cases, like you just said, where the accuser may believe it. And in this case, they did believe it. You have to be a little sensitive. I mean, we're all human beings and so forth. You don't want to, hurt this young girl who went through a lot just going through the court process herself, right? She firmly believed it and may still to this day believe that something happened. So you have to be sensitive to that. So I would say it's a balancing test and it's on a case-by-case basis.
Yeah, amazing. So do you still have a relationship with the client?
Yeah. So, all right. So when we talked about my favorite part of the business, it's the relationships. And this case, the reason that I chose this case was because it's an A to Z case, the full spectrum, right? It is, I didn't know him. I didn't know the family to where we are today. And today he's one of my closest friends in the world.
That's amazing.
It's great. After the trial, his girlfriend at the time became his fiance very quickly and shortly thereafter. And this is funny, at the wedding. So I remember his mom, I was there with my wife, and his mom was coming down the aisle for the wedding. And they started giving me a hard time, some of the people who were at the wedding who knew me, because they were laughing. They said 2 people in the wedding were crying. One was the groom's mom and one was me.
I love that.
So we were so invested in this case. And it was just kind of like, this is why I do what I do. And seeing him have that wedding was fantastic. And we've been at our births for our kids.
Incredible.
We've visited each other at times of need, and we know each other's families very well. And so this case just has had it all. It really had every aspect of the legal system, the criminal justice system. It had everything about kind of humanity and relationships. And so it's great.
Yeah, I'm so glad you shared this with us. And I hope our listeners now know why I was so agreeable to allowing this case to be discussed, notwithstanding my own practice. And that's because I do think it's important to understand the other side.
Yeah.
And it's always important to think about the criminal justice system and those that are either falsely accused or just downright innocent. And what you do is remarkable. I am so glad you came on the show, but I'm not going to let you leave yet because I always like to ask these questions of my guests, and I think it's especially important to ask you. We have younger lawyers listening to this podcast. A few years ago, you started a boot camp actually through the Cleveland Metropolitan Bar Association that you were president of for a while. And the idea, of course, is to train these young lawyers. So what advice can you give to the younger generation of lawyers? And then we could let you go after that.
That's a great question. Do the right thing. I know it sounds pretty simple. Do the right thing. Practice in an area that you're passionate about. Do what your gut and your instincts tell you to do, because your reputation means everything. I'm a lawyer who doesn't like lawyer jokes at all. I love our profession, and I don't like the lawyer jokes at all. I think it's one of the most noble professions that there is. And I believe that you should do right by the profession, make it better than it was when you came into it. recognize what's at stake. It's really easy sometimes for lawyers, new lawyers, we're surrounded by other lawyers. We don't realize sometimes or forget how important it is what we do and the impact that what we do has on other people. And I think you should never let yourself forget what that person came to you for and how much meaning what they're asking you to do has for them. You know, we've sat here, we've talked about one's liberty, but in all the areas of law that are out there, you know, whether it's family law and having access to your children, or a family member was hurt terribly in an accident and is trying to be compensated for it. They don't come to us for good things, right? They come to us when they're at their greatest time of need. And I think if you always keep that right out in front of you, it's not me, it's what does this person need? Where are they? How do they feel? If you cater to that, just make sure that at the end of the day, you can look back and you can say, I gave everything for this person 100%. And I think that's it for me. I can look back over the course of my career and I can say I gave every person 100%. And if you can do that, then you really took advantage of the great position of being a lawyer, and you made sure that you gave each client the benefit of your best.
Yeah, thanks for that advice. It's great advice. I mean, we as lawyers, especially when we get busier and busier, right, sometimes the client isn't at the forefront of our thoughts all the time, but we have to do that. We have to just be thinking, what is in our client's best interest and right, how do I get there? So thank you, Ian. I can't tell you, I enjoyed this conversation so much. It is wonderful to be with you and see you again. And
my pleasure. Thank you.
Thanks.
Thank you.
Thank you.
All right.